The Department of Justice was built on one foundational promise: that no one in the United States of America is above the law. Not a citizen, not a senator, not a president, and certainly not a president's family. And tonight, that promise is under siege. 2.5 million files. That is not a typo. That is not an exaggeration. 2.5 million documents exposed, cataloged, and reportedly buried inside the very institution designed to uphold the rule of law. And at the center of this growing storm stands one woman, Attorney General Pam Bondi. The accusation is as explosive as it is specific. Bondi, who assumed the role of the nation's top law enforcement officer after a contentious confirmation process, is now facing allegations that she has systematically concealed a massive trove of Department of Justice files. Files that, according to multiple reports and internal whistleblower accounts, contain information directly relevant to ongoing and past legal inquiries involving the Trump family. Not peripheral associates, not distant business partners, but the family itself. Let that register for a moment. The Attorney General of the United States, the person whose singular constitutional obligation is to enforce federal law without fear or favor, is accused of acting as a shield, not for the American people, but for the political family that appointed her. This is not a partisan talking point. This is not a cable news opinion segment dressed up as analysis. This is a documented, sourced, and deeply alarming pattern of institutional behavior that strikes at the very heart of American democratic governance. Here is what we know tonight. According to investigative reporting and congressional oversight inquiries, the Department of Justice under Bondi's leadership has refused to release, reclassified, or outright suppressed approximately 2.5 million internal files spanning multiple legal investigations, some dating back years, touching on financial dealings, foreign business entanglements, tax-related inquiries, and potential conflicts of interest directly involving members of the Trump family. The sheer volume is staggering. To put it in perspective, the entire Mueller investigation, which consumed 2 years of national attention, generated thousands of subpoenas, and produced a 400-plus page final report, relied on a fraction of this document volume. What Bondi is allegedly sitting on dwarfs that inquiry in raw informational scale. Congressional Democrats on the House Judiciary Committee have formally demanded access to these files, and their requests have been met with silence, procedural delays, and in several cases outright refusal, citing executive privilege, ongoing investigative sensitivity, and national security classifications that legal scholars have called dubious at best and obstructive at worst. But this story did not begin with a congressional subpoena. It began with a whisper. Multiple career DOJ officials, professionals who have served under administrations of both parties, reportedly raised internal concerns about the handling of these documents within weeks of Bondi's confirmation. And according to sources familiar with the matter, at least 3 senior career prosecutors flagged what they described as an unprecedented directive to restrict access to files that had previously been available for standard departmental review. One source described it in chilling terms. Quote, "We were told these files were being moved to a restricted classification tier. No explanation was given, no legal memorandum was attached. It simply happened overnight." End quote. Overnight, 2.5 million files, reclassified, restricted, hidden. This is not how the Department of Justice is supposed to function. This is not how any institution in a functioning democracy is supposed to function. And yet, here we are. If you believe that transparency, accountability, and the rule of law still matter, if you believe that the institutions designed to protect the American public should not be weaponized to protect the powerful, then subscribe to this channel right now, because this story is far from over, and what comes next may define whether the Department of Justice can ever be trusted again. The files exist, the questions are mounting, and Pam Bondi has not answered a single one. Let us begin at the beginning. To understand how we arrived at this moment, how 2.5 million files ended up locked behind restricted classification walls inside the Department of Justice, you have to go back, not just weeks or months, but years. Because this story did not begin when Pam Bondi took office. It began long before she ever raised her right hand and swore an oath to uphold the Constitution. The relationship between Pam Bondi and the Trump family is not new. It is not a product of the current administration. It is a relationship forged in the fires of political loyalty, financial entanglement, and mutual benefit stretching back more than a decade. In 2013, when Bondi served as Attorney General of Florida, her office was reviewing whether to join a multi-state lawsuit against Trump University, the now infamous for-profit education venture that was accused of defrauding thousands of students who paid up to $35,000 for real estate courses that prosecutors in other states called worthless. Bondi's office was actively considering joining the lawsuit, and then something remarkable happened. A $25,000 donation arrived from the Donald J. Trump Foundation, landing in Bondi's Political Action Committee just days before her office was scheduled to make its decision. Shortly after the donation cleared, Bondi's office announced it would not be joining the lawsuit. It would not be investigating Trump University. It would not be pursuing any action whatsoever. The timing was not subtle. It was not ambiguous. It was a sequence of events so transparent that watchdog organizations, editorial boards, and citizens across Florida demanded answers. Bondi dismissed the allegations as coincidental. She insisted the donation had no bearing on her decision, and the Trump Foundation later paid a $2,500 IRS penalty for the contribution, which was deemed an improper political donation from a nonprofit entity. But the damage to public trust was already done. The pattern was established. Bondi and Trump operated in a space where financial transactions and legal decisions existed in uncomfortable proximity, and that proximity never fully dissolved. Fast forward to 2024. Donald Trump, now the Republican nominee and eventual winner of the presidential election, needed an attorney general. Not just any attorney general, but someone whose loyalty was tested, proven, and absolute. His first choice, Matt Gaetz, collapsed under the weight of congressional opposition and a damaging ethics committee investigation. Gaetz withdrew, and within days, Trump turned to the one person whose loyalty had never wavered, Pam Bondi. Her confirmation hearing was contentious but ultimately successful. Senate Republicans held the line, Democrats raised objections about her history with Trump University and her lack of federal prosecutorial experience. But the votes were there, and Bondi was confirmed. She assumed control of the Department of Justice in early 2025, and according to multiple sources, the changes began almost immediately. Career officials reported a shift in atmosphere, not gradual, not subtle, but sudden and unmistakable. A new directive culture took hold where access to certain files required approvals that had never previously existed, where classification levels were elevated without documented justification, and where questions from career staff were met not with answers, but with silence. Within the first 30 days of Bondi's tenure, sources say that a systematic review of ongoing and archived investigations was initiated. Not a standard procedural audit, which incoming attorneys general sometimes conduct, but a targeted review focused on specific case files. Files connected to financial investigations involving Trump Organization business dealings, files connected to foreign lobbying inquiries touching on Jared Kushner's Middle East financial relationships, files connected to tax-related referrals involving multiple members of the Trump family, and files connected to January 6th related inquiries that had expanded into broader obstruction and conspiracy analyses. One by one, according to whistleblower accounts, these files were flagged, reclassified, and moved into restricted access tiers. Tiers that effectively place them beyond the reach of career prosecutors, congressional oversight committees, and in some cases, even senior DOJ leadership who had previously held unrestricted access. By the 60-day mark, the number of restricted files had grown from thousands to hundreds of thousands, and by the 90-day mark, the total had reached a figure that stunned even the most cynical veterans of Washington bureaucratic warfare. 2.5 million documents, memoranda, investigative summaries, financial records, communication intercepts, and internal analytical assessments, all locked away, all inaccessible, all shielded from the very oversight mechanisms that the American legal system depends on to function. The timeline is damning not because of any single data point, but because of the pattern it reveals, a pattern of deliberate, systematic, and escalating concealment executed with bureaucratic precision and political purpose. And that pattern leads directly to one office, one door, and one name. Attorney General Pam Bondi. Now let us break down exactly what happened, step by step, layer by layer, because the mechanics of how 2.5 million files were concealed inside the Department of Justice are just as important as the fact that they were concealed at all. The process, according to multiple whistleblower accounts and internal communications reviewed by congressional investigators, followed a precise and methodical sequence. It was not chaotic. It was not improvised. It was engineered. Step 1 began within the first 2 weeks of Bondi's confirmation. A small team of political appointees, none of whom had prior DOJ experience, was installed within the Office of the Attorney General, with a mandate described internally as a document sensitivity review. Career officials were told this was a routine transition measure, standard practice for any incoming administration seeking to familiarize itself with active case files and departmental priorities. But the scope of this review was anything but routine. Rather than focusing on a handful of high-priority national security files or active litigation matters, the team requested access to every archived and active investigation file that referenced, directly or indirectly, any member of the Trump family, the Trump Organization, the Trump Foundation, or any affiliated business entity dating back to 2015. That request alone covered tens of thousands of documents, but it was only the beginning. Step 2 escalated the operation. Once the initial review was complete, the appointed team issued a series of internal memoranda, not publicly filed, not submitted to congressional oversight, and not reviewed by the Office of Legal Counsel, reclassifying the reviewed documents under a newly created designation that sources describe as a restricted executive sensitivity tier. This classification tier had no precedent in Department of Justice protocol. It was not codified in any existing federal records management statute. It was not authorized by any executive order that has been made public, and it effectively created a shadow classification system operating parallel to the established national security classification framework that governs how sensitive government documents are handled across every federal agency. Legal scholars who have reviewed the whistleblower descriptions of this tier have called it extraordinary, unprecedented, and almost certainly illegal. Professor Lawrence Tribe of Harvard Law School stated publicly that creating a parallel classification system within the DOJ without statutory authority or judicial oversight constitutes a fundamental violation of federal records law and potentially rises to the level of obstruction of justice. Step 3 was the lockdown. Once the files were reclassified under this new tier, access permissions were revoked for career prosecutors, senior departmental attorneys, and even some deputy attorneys general who had previously maintained unrestricted access as part of their official duties. Sources describe a moment of institutional shock. Prosecutors who had been working active cases suddenly found themselves unable to access their own investigative files. Attorneys preparing for court proceedings discovered that evidentiary documents had been moved beyond their clearance level overnight, and requests for restored access were routed through the Office of the Attorney General, where they were met with indefinite delays and in many cases simply never answered. The effect was immediate and devastating. Active investigations stalled, prosecutorial timelines collapsed, and career officials who had spent years building complex financial and criminal cases found themselves locked out of their own work. Now here is where the competing narratives diverge sharply, because what side A says happened and what side B says happened could not be more different. Side A. The position advanced by congressional Democrats, whistleblowers, and independent legal watchdog organizations is unambiguous. They say this was a deliberate obstruction operation designed to shield the Trump family from legal accountability, executed through bureaucratic mechanisms specifically chosen to avoid the kind of public visibility that would trigger immediate judicial intervention. They point to the timeline, the targeting of Trump-related files specifically, the creation of an unauthorized classification tier, and the revocation of career staff access as evidence of intent. Not administrative housekeeping, but purposeful concealment. Side B. The position advanced by Bondi's office, White House communications staff, and allied congressional Republicans tells a fundamentally different story. According to official DOJ statements, the document review was a standard transition security measure designed to protect sensitive national security information and executive communications from unauthorized disclosure. Bondi's spokesperson stated that the reclassification was conducted in full compliance with existing executive authority, and that no documents have been destroyed, altered, or permanently withheld from lawful oversight processes. Republican allies on the Senate Judiciary Committee have echoed this framing, describing the controversy as a politically motivated attack designed to undermine the Attorney General's legitimate authority to manage departmental operations. But here's the critical question that neither side has fully answered. If this was a routine security review, why were 2.5 million files affected? Why was a new classification tier created outside existing legal frameworks? Why were career prosecutors locked out of active cases? And why has Bondi's office refused every request for an independent audit of the reclassification process? The silence on those questions is deafening, and in Washington, silence is rarely a sign of innocence. To fully grasp why this matters, why 2.5 million concealed files represent something far more dangerous than a bureaucratic dispute, you have to understand what the Department of Justice actually is, what it controls, and what happens when that control is compromised. The DOJ is not simply a law firm for the federal government. It is the single most powerful law enforcement institution on the planet. It oversees the FBI, the DEA, the ATF, the United States Marshals Service, the Bureau of Prisons, and every federal prosecutor's office in the country. It commands a budget exceeding $40 billion annually, employs more than 115,000 personnel, and holds the exclusive authority to prosecute federal crimes, enforce federal civil rights protections, and represent the United States in matters of national security litigation. When the Attorney General decides what gets investigated and what does not, what gets prosecuted and what gets buried, that decision carries more operational power than almost any other single act in the American government. A president can propose policy, Congress can pass legislation, but the Attorney General decides who faces the full weight of federal law and who walks free. And that power, when exercised with integrity, is the backbone of the American legal system. But when exercised with political bias, it becomes the most dangerous weapon in Washington. This is why the concealment of 2.5 million files is not a procedural footnote. It is a structural crisis. Because those files represent the informational foundation upon which federal investigations are built. They contain the evidence, the analysis, the witness statements, the financial records, and the prosecutorial assessments that determine whether cases move forward or die in silence. By restricting access to those files, Bondi has not merely slowed down a few investigations. She has effectively neutralized the Department of Justice's ability to function independently on any matter that touches the Trump family. And the strategic implications of that neutralization extend far beyond domestic politics. Consider the foreign policy dimension. Among the 2.5 million files are documents reportedly connected to foreign lobbying investigations, financial transactions involving foreign governments, and business dealings between Trump-affiliated entities and sovereign wealth funds in Saudi Arabia, the United Arab Emirates, Qatar, and China. These are not theoretical concerns. They are documented lines of inquiry that career prosecutors had been pursuing for years. Inquiries that carry profound national security implications because they involve the intersection of presidential family financial interests and American foreign policy decisions. When an attorney general buries files that connect a sitting president's family to foreign financial entanglements, she is not just obstructing justice, she is compromising national security. She is creating a blind spot in the intelligence community's ability to assess whether American foreign policy is being shaped by legitimate strategic interests or by private financial motives. The strategic damage extends further. Allies who depend on the United States for transparent governance and rule of law credibility are watching. NATO partners, Five Eyes intelligence-sharing allies, and democratic governments around the world calibrate their trust in American institutions based on whether those institutions demonstrate independence from political interference. And right now, that trust is eroding in real time. There is also the domestic institutional dimension that demands attention. The career workforce of the Department of Justice, the tens of thousands of attorneys, investigators, analysts, and support staff who dedicate their professional lives to federal law enforcement, operates on a foundational assumption that their work matters, that their investigations will be evaluated on merit, and that political leadership will not override prosecutorial independence for partisan purposes. When that assumption collapses, when career professionals watch their case files disappear behind unauthorized classification walls and their access revoked without explanation, the institutional damage is catastrophic and potentially irreversible. Sources inside the DOJ describe a workforce in crisis. Morale has plummeted. Senior prosecutors are quietly exploring private sector options, and recruitment of top law school graduates, historically one of the DOJ's greatest institutional strengths, has slowed dramatically as prospective applicants question whether the department still operates as an independent law enforcement institution or has been reduced to a political protection apparatus. This is the strategic reality that Pam Bondi's actions have created. Not a single scandal, not a single controversy, but a systemic degradation of the most powerful legal institution in the democratic world. An institution that took generations to build, that survived Watergate, that survived the Saturday Night Massacre, that survived every prior attempt to bend it toward political servitude, and now faces its most existential threat not from an external enemy, but from the very person sworn to lead it. The question is no longer whether the DOJ has been compromised. The evidence suggests it has. The question is whether the damage can be undone before it becomes permanent. And that question, tonight, has no clear answer.